¿Qué les pareció la charla con Father Pete? Él es muy cómico, ¿no? Digo yo, a mí me cae bien. Alie y Rachael, bueno, no sé, Rachael, ¿tú viajaste aquí, no? ¿O no?
Sorry?
Did you go to Kino with Campus Ministry? I don't know. Alie sí, conmigo, ¿verdad?
Sí.
¿Tú te acuerdas de Father Pete?
Sí.
El jesuita vaquero, sí. Él vino a la clase el martes, así que habló con ellas el martes. Bueno, ya que está Nelly, voy a empezar. Me es un honor y un tremendo placer presentarles a Alie Iwanenko, que recién se casó, así que felicitaciones. Y a Rachael Sparacino, que hoy, de hecho, tuvo una parte de su examen del bar de Nueva York. Así que también te felicito. Las dos son ex alumnas mías. Se graduaron de Canisius hace unos añitos nomás. Y las dos se inspiraron a estudiar la ley, y son ya abogadas que abocan por los derechos de los inmigrantes. ¿Ya? Aunque sí hablan español las dos, la presentación va a ser en inglés porque la ley se escribe en inglés, ¿ya? Y es complicado hablar de la ley en español, así que la presentación será en inglés. Bien. Y por último, pueden interrumpirlas si tienen preguntas para que se aclaren las cosas, y al final de la presentación también pueden hacerles preguntas. Ellas han hecho eso antes y han trabajado en muchos aspectos de la inmigración, así que son muy sabias en lo que está pasando. Bien, entonces Alie y Rachael, les paso la palabra y bienvenidas. Y bueno, una clase de puras mujeres y las dos abogadas, así que ya hay que hablar todo en femenino, ya que ustedes dominan el mundo ya hoy en día, que está bien. Entonces, Alie, congratulations again on your wedding. And Rachael, congratulations on your first leg of your bar certification processes. So
I don't know how you did that, Rachel. I took the bar exam in July, and I know New York has like a separate section that's not the full bar exam, but I was done. Like, I was not a functional human being after I did that. So kudos to you for being here, because I probably would have like gone home and went to bed. So.
The fear has really just kind of kept me going. My own anxiety is really why I'm here. Okay. See.
do I need to make you guys co-hosts, or can you share?
I think Rachel.
Can you see my screen?
Yeah.
Yep, we can see, so we're good.
Okay, perfect. So then we're good. All right.
I am recording if that's okay.
Yeah, that's fine. So like Professor Reitzma said, we're here to just kind of give you like a basic overview of US immigration law. So we're gonna tell you just a little bit about us, even though Richard did a good introduction already. We're going to talk about the basics of US immigration, types of immigration. I prepared a little like family-based green card example so you guys can get like an idea of how immigration kind of works, at least in a family sense. And then some recent policy changes, and then Alie is going to dive into deportation. And then we're just going to do a review. So Alie, do you want to just go first?
Sure. So I graduated in 2017, which seems like forever ago now. I was in the honors program, and I studied international relations, Spanish, and Latin American studies. After I graduated, I moved to Erie, Pennsylvania, and I did a year with AmeriCorps, which is Volunteer in Service to America. And I was at United Way of Erie County, working on their community schools initiative. So I was working with Erie's public schools, and we were really trying to bring resources into the schools. So if there was a need for uniforms or school supplies or whatever it was, rather than having families go out to all these organizations and try to find everything, we were bringing those into the schools. And then after I did that for a year, I moved to Pittsburgh and I went to Duquesne. I just graduated in May 2021. I took the July 2021 Pennsylvania bar exam. I got married in August and I just started a job as an associate attorney in Erie. So I moved back from Pittsburgh to Erie and I've been here for 2 weeks now. So far, so good, but super busy, super crazy. I did immigration law in Pittsburgh at a small law firm there. The law firm that I work at now doesn't do that for paying clients, but I do want to do that work pro bono and get involved with the Erie County Bar Association to continue doing that because it's really needed.
All right. So I graduated from Canisius in 2019, which also feels like a long time ago. I got my degree in international relations, history, and European studies with a Spanish minor. And I'm currently at UB School of Law. I'll be graduating in May. So actually, this is my last semester. Like Richard said, I just took the New York bar. I'll be taking the Universal Bar exam in February. And I'll be spending my spring semester as a pro bono scholar, which is a special New York program that allows third year law students to spend their final semester of law school working pro bono for the full semester. So I'll be doing that next spring or this coming spring, working at Journey's End, which is where I currently work as a law clerk. I've worked there for about 2 years or so now. Kind of in the interim there, I worked as a law clerk as well at Berardi Immigration Law, which I got the opportunity to work with a lot of business-based immigration. At Journey's End, we deal a lot of refugee and asylee immigration. And I also work as like a legal assistant with the NAFTA panel, which is not immigration related, but it's something else that I do, so it's on here. So the basics of US immigration law. So immigration law is governed by Congress, which might sound surprising because everything coming out of immigration law in the past couple of years, decades, has been by executive order. So a lot of people, even in law school, think that, oh, the executive controls immigration. He doesn't. It's technically under Congress. The statute for immigration is the INA, the Immigration and Nationality Act, which was codified in 1952 and was last amended in the late 90s. So immigration law is also sponsorship based in the US. So that means you have to have, any immigrant has to have a sponsor to sponsor them to immigrate to the US. So for example, you have to have like a family member sponsoring you, an employer sponsoring you. In the cases of like refugees and asylees, they have the US government sponsoring them. And then kind of the key players in immigration law is the Department of Homeland Security, which controls USCIS, which is US Citizenship and Immigration Services, which is who I primarily deal with. That's where pretty much any applications for any kind of immigration or non-immigrant status go to. And then ICE, which a lot of people know, it's the enforcement branch of immigration if you are undocumented or overstay. And then there is the EOIR under the DOJ. So they're the Executive Office for Immigration Review. And that's basically, Alie, I guess, can touch upon that more because that deals more with deportation. So the Board of Immigration Appeals and immigration judges.
Real quick, because I think we're going to go into this more, but just as a premise, there are all these facets of immigration law, but I do want to draw the distinction between affirmative and defensive. So affirmative cases is what happens, you come into the US with a visa legally, or you have permission to be in the United States, and you're applying to change your status, which is kind of what Rachel's going to be talking about. But then there's the defensive part. So that's when you're put into removal proceedings and you're using something as a defense so that you're not going to be deported. So you can either apply before you come into the United States, or you can apply once you're in the United States as a defense to something. So I just want you to keep that in mind. There are these different processes, and depending on where you're at, you're either going to deal with USCIS or you're going to deal with an immigration judge and the Board of Immigration Appeals. And those are two completely separate instances and two separate pieces of immigration, which is why it gets very confusing.
So exactly what Alie just said. So right now I'll just go through a family-based green card example with you guys. So this is something that I deal a lot with where I work, and it is pretty common to come across in immigration, especially if you're dealing with something more so with USCIS than deportation cases. So in our example, Alie is a US citizen and wants to sponsor her 25-year-old brother, who is a citizen of Mexico, who lives in the United States. To live in the United States, sorry. So the first thing she has to do is file a petition with USCIS, which is a petition for an alien relative to just kind of show that they actually have a bona fide relationship, that they're actually siblings. That is currently taking about like 2 years to process. And then Alie's brother would have to wait for a visa number to become available for him. Once a visa number is available, you can put, you have to submit another application to ask the US government for a green card. And so this is, it kind of just branches off here. So if he's outside of the United States, he would have to go to an embassy for an interview. If he's legally inside the United States, he can file an adjustment of status form, which is an I-485. So just to kind of carry it out, that part two where I said he has to wait for a visa number to be available, this is common with a lot of immigrants. The only exception are immediate relatives. So parents of US citizens, spouses of US citizens, minor children of US citizens are immediate relatives. So we in the US, in our immigration system, create family preferences as well as employment-based preferences. But in these ones, you can see like your first preference is to unmarried sons and daughters of US citizens. The second preference gets broken down into an F2A and F2B. The A is for spouses and children of green card holders. B is for unmarried sons and daughters of green card holders. An F3 is married sons and daughters of US citizens. And then an F4, which is what we would be looking at in our case, is brothers and sisters of adult US citizens. So they're kind of at the short end of the stick. They kind of get whatever is left of the visas after these three, they go through these other kind of four categories, essentially. So then every month, the Department of State publishes the Visa Bulletin, which is what we're looking at now. And this is actually current as of, actually it's October's Visa Bulletin. They publish it a little bit earlier. So this is what it's going to be. And you can see when you look at like the family sponsored for an F4 category, and then it breaks it down by country. And I don't know why I'm pointing at my screen and you guys can't tell, but it breaks it down by country. And so under US immigration law, no country can be more than 7% of the amount of green cards that we give out, which is why you end up getting these distinctions of different countries because there's so many more applications from them than green cards available. So like I said, we're talking about her brother from Mexico, because it's an adult sibling of a US citizen coming from Mexico. They're currently processing those applications, which were filed in February of 1999. So to kind of continue walking through this, you submit your I-130 application. As soon as you submit it, you get a queue number, essentially a preference date, which is what they're going to go off of for the Visa Bulletin. And essentially you have to wait, this is what, 22 years now. So you're waiting 22 years for a Visa Bulletin to become available, a green card to become available, which then you can submit either your I-485, which is taking 2 years to process at this point, or, sorry, Richard, I was trying to read your question. Or they can process outside of an embassy, which is on its own different timeline that I don't even understand. No one does. They kind of do their own thing in the State Department. But essentially, that's 24 years that you're looking at. So if he files at the age of 25, he has to wait 22 years and will be correct. Essentially, yeah, he'd be like 47 when he's finally able to like get here. And then the green card application, I just wanted to show you guys what like our Buffalo field office is doing right now. It's taking them about 11 months to 27 months to process these. So like I said, about another 2 years for your green card after you wait that 22 years for a visa to become available to even submit this application.
And then you have to have a green card for 5 years before you can apply for citizenship. So if you're looking at the beginning of this process to the end of this process from Mexico, particularly, now other countries have different wait times, but the crisis in the United States is from Mexico. When we talk about why aren't people doing this legally, you're looking at a 30-year process from the time you send your paper application in the mail until you can become a citizen. So
And that also
take that for what it's worth.
And
so
then
if they got married and have children, right, those people aren't part of the initial filing.
Correct. And your category can change when your status changes, which is
right. So if you were unmarried when they filed for you and you got married, you went from being a preference like 1 category, let's say, to now preference 3. So it can change so many things.
And what if the sibling were to pass away in the interim?
The sibling like sponsoring them?
Yes.
I believe that's just kind of the end of it, unless someone else, another qualifying family member can sponsor
you would
them.
have to have a co-sponsor take over that application. But the co-sponsor would have to be the same category, or otherwise you change category. So if you only have a brother and a sister and you don't have another sibling, you wouldn't fall under that F4. You wouldn't fall under that same category as a brother or a sister. So then that changes who your sponsorship is as well.
And if your category changes through death or your own marriage or having children, does the process start over, or in terms of the timeline?
I mean, I've seen it happen where like if there's a co-sponsor of the same category, like they keep the same date, but I've only seen it like once happen. I don't know, Alie, if you have.
Yeah, I haven't seen it. It's not common, at least from what I've seen either, but I have seen, it was a step mom. So she was applying for her stepdaughters to come through the dad, but the dad died. So originally the dad was trying to sponsor, but you have to do a lot more work. Like we had to write this whole special legal argument about why the stepmom should still be allowed to sponsor the daughters, even though the husband died, because she doesn't have the blood familial relationship. It would have been through the dad. So and that's still pending. I wrote that last year, and like Rachael said, it's taking about 2 years to process. So I don't know if they're going to accept it. We tried. I mean, you can try to make whatever arguments you want. It's just such a mess that it takes so long. By the time they figure out what they're doing, things have changed on your end too. So I think it's possible. The categories, it's easiest if you're changing from the same category. Like if your co-sponsor is the same category, it gets more complicated when that relationship changes.
Right. So if you just switch from one sibling to another, as opposed to a sibling to, say, I don't know, a cousin or an uncle or whatever.
Yeah, which it would have to be a parent or a child, because fun fact, aunts and uncles and cousins, you're not qualifying relatives.
Which is important to note, because most families of immigrants in Buffalo came over because there was an uncle here. That is, I mean, that happened all the time in the past. That's not the case now. And I think people need to be aware of that, because how many times I've heard Buffalonians argue, well, my grandpa came because his, you know, his great uncle was here. Well, that was then.
That was when you could just show up on the island and they were just like, sure,
Especially-
yeah, you stowed away.
Especially if you were white.
Even still now, sometimes.
Right. I mean, no, I thank you for clarifying this, because I mean, 30 years is a very long time,
Right.
in a person's life. So things change. Yeah.
And even so, what the slide currently is on, USCIS has this lovely discretion policy, which is basically comes at the end of after you've done everything. So you could have done everything right for this whole 30-year period. And basically they can just be like, yeah, but I don't really think so. And they can just deny it. And it's like, well, you met your eligibility requirements, but for some reason, like, I'm just not buying it. Who knows? Maybe they had, like, they woke up on the wrong side of the bed that day. They just decide, no. So there's 30 years kind of wasted off of potentially just a whim.
Can that
And
be appealed?
I'm sorry?
Can that be appealed?
No. What you can do is you can go to the USCIS officer's supervisor and be like, hey, your officer messed up. But I think you can probably figure out how many times if you go to a USCIS officer supervisor and it's like, your officer messed up, that they're going to side with you over their employee. Like, it doesn't happen that often. And for it to happen, you have to make either a really big scene or they have to have really messed up. It does not happen that often.
And the other issue with discretion is it depends on whose desk that application lands on. So every USCIS office has USCIS officers. And I might read it and say, oh yeah, this person qualifies and grant it. And Rachel might read a different one, same case, same family member, could be, you know, the brother or a cousin who also applied at the same time. And Rachel could say, actually, I don't think it's as good of a case, and deny. So it really depends on what officer you get. And human bias plays into this a lot as to the discretion. I did see a question come in.
So how old do you have to be to apply? So if you're a child petitioning for your parent, you have to be 21 years old. A parent applying for their child, they can do that at birth, I believe. Yeah. Well, that would also be kind of, I mean, if they're born here, they're a US citizen already, or if they're like a young kid and the parent becomes a citizen, like they can derive citizenship. But yeah, essentially, I think it would be at birth.
Yeah, I want to just touch on that quickly about deriving, because I think a lot of people, I got a lot of clients who would come in when the parents became naturalized and they would say, I want you, it's an N600 is what you apply for the child. And it's like thousands of dollars. And they're like, I want you to apply for this N600 for my child because now I became a citizen and I want them to become a citizen. I think it's 16. As long as they're under 16, they automatically become a citizen when the parent does. And so you can apply for a passport, which is, you know, $100, a lot cheaper than this N600 form that you would fill out to get citizenship for the children. And so that's a huge moneymaker too, is people who don't know that, and people who are pro se and are representing themselves are filling out this form online to get a piece of paper. It's not a travel document. It's not a passport. It's not a government ID. It's like a certificate piece of paper that says your child is a US citizen. But if they're a minor and you became a citizen, they also are now a citizen. So you're wasting all of that money when you could actually just get a passport for your child, which is actually a government issued document. So there are all these ways that it gets really confusing when you get into immigration, and people who are trying to navigate this without any type of legal background have a really hard time. I have a really hard time, and I went to law school for 3 years. So it's, it's complicated.
Yeah. I will say though, just real quick, with like the N600, the good thing about like I do a couple of those, the benefit is that those don't ever expire, whereas your passport will eventually expire and you do have to keep reapplying. And sometimes it can be a fight with like whoever you're going to being like, no, they're a citizen. Like I can prove it because I can prove that I'm a citizen, but sometimes it's just easier for the N600. And then I see we have a hand raised. Yeah, if you wanted.
I guess I have a question. So
Yeah.
like, is there nothing that manages people from just making whimsical decisions? Like there's no like standard to follow when you guys are looking through these cases?
Yeah, so I mean, if it's like a glaring mistake that the officer is like making, you can and you have a lawyer, your lawyer can obviously like argue that with who's ever making the decision and argue it with the supervisor. But really like there's no like complaint process. Like you could you, Alie, do you know, could you submit an ombudsman request for something like that?
So
I've only done them for like processing times. I haven't done them for like your officers.
Yeah, and I've done them like you can, I think you have 30 days to appeal, but that's only for a decision. So let's say you get, USCIS will give you like a notice of intent to deny, and they'll say, hey, we're giving you this notice because we intend to deny your application. And then you have 30 days to convince us otherwise as to why we shouldn't deny your application. You can then submit additional evidence, but once you get that decision, that is the decision. So they do give you a little bit of room to try to strengthen your case, but I haven't had anything like once you get your final decision, you basically you can apply as many times as you want. So let's say they deny your green card, you can always submit another green card application. Now you have to repay the fee. You have to re-wait the whole waiting time. So it's not like an end all be all where you're completely stuck. It just, you're put in a crappy situation. There are guidelines. So USCIS, they're supposed to every year. I don't think they actually do it every year, but there is a policy manual. It's internal, so it's not really available to the public. You can get it if you request it, and it lays out the policies of all of their officers. I mean, that only goes so far. So there is a manual. They are supposed to follow the manual. At the end of the day, there's really no way to know how they're making these decisions because they can blanket it in this discretionary policy, which is where the issue lies.
I will say too, the amount of times that I've had to like argue something in a letter to an officer about what their policy manual says. Like I've literally had to quote policy manual language and then be like, I had to argue to them that 1 year is 365 days. I've also had an attorney I worked with, just to show you kind of like how absurd it can be. Back when the whole public charge rule was a thing, but then also not a thing, it was getting enjoined, but then it was still on for certain applications. We had a marriage-based green card interview, and based on when the couple filed, they were not subject to the public charge rule. And according to the USCIS policy manual and the guidance that they put out for attorneys. And they went to this interview with our attorney, and the officer said, well, you don't have the new public charge form, you need to have that. And the attorney was like, oh, like, because we filed on this date, like, according to the policy manual, we're not supposed to. And they went back and forth on it for a bit. And eventually, you know, you don't want to upset the officer that's going to adjudicate your case. So they decided, okay, we'll bring the form back by the end of the day. Like the officer was like, okay, we'll let you bring it back later and we'll redo this then. So they spent pretty much all day getting the form together. When they went back, the attorney I worked with, he had like the policy manual printed out. He had highlighted like where it says that this doesn't apply to them. And he gave it to the officer and he's like, see, like, this is what it said. And the officer goes, yeah, you know, we talked about that with my supervisor and we decided we're not following that. And he was like, then why are you putting it out there for like attorneys to look at and understand? And also when they handed in the form, it was like a stack of papers like this thick. The officer didn't even look at it, just checked that it was submitted on the box. Didn't even look at what was in the paperwork. Just was like, cool, you have it, great, and moved on. And it was just, so that's what it's kind of like sometimes. Anyway, I digress. Something else I just wanted to point out to you guys is you can see right here, like the receipt date for case inquiry. So, and there's like an estimated time range, the type of form it is. But we see this a lot with, you know, you're kind of waiting around for your case and you're kind of wondering, well, when's it going? Like, is anything happening with it? You cannot submit an inquiry until this date has like, so if I submitted a case in, let's say October of 2018, and I'm basing it on being a refugee, it's been a while, but I can't even ask USCIS about my case until this date has like passed essentially. So I'm trying to figure out the way to word this, and this would be a lot better if my brain wasn't mush after this bar exam.
That's okay. So basically what this date is the applications that were received on that date, those are the applications they're processing. So if you submitted your I-485 based on refugee status on September 13th, 2018, your case is being reviewed today as far as USCIS standards go. But if I submitted my case last year, September of 2020, I can't ask USCIS for a case status because they're not even looking at my case yet. It hasn't even started to get processed yet. So these are the dates where you're allowed to submit an inquiry. And for a U visa, I'll tell you, because I did the U visas. U visa is based on if you were a victim of a crime in the United States and you helped with the investigation. Those take 4.5 years to process. For victims of a violent crime in the United States, 4.5 years. So I would get clients all the time. I worked there for 2 years who are like, hey, when you started here, you submitted my U visa application. It's been 2 years. And I have to tell them like, sorry, we still have 2.5 more years to go. There's like nothing I can do about it. So I send them these all the time because they think I'm lying, and I screenshot it and I'm like, this is the date USCIS is saying that they're processing from. So it's very frustrating.
Yeah. And yes, thank you, Alie. That was way more eloquent than I could have put together right now. So guys, if something I say doesn't make sense, just let me know because it's been a long day. So some policy changes coming. So starting October 1st, all applicants for green cards are going to be required to have the COVID-19 vaccine. They also have to have their flu shot, but that happens annually during flu season. And then kind of working backwards, in July 20th, 2021, they officially kind of got rid of the no blank policy. So for certain applications, I think most notably for me, probably Alie, was the asylum application. Essentially, the no blank policy was that you can't have any blank spots on your forms, for example, asylum, which was really stupid because they made you write N/A in every single box. And there was someone there whose job was to go through and make sure you put N/A in every box. Otherwise, they would send it back to you and be like, no, you did it wrong. And that was their job.
Not only that, but okay, COVID, right? No money. Like USCIS is closing all these offices, firing all these people, and they're wasting postage. They're spending money on mail to send me back an application which that doesn't have NA on it, for me to fill it in the blank to resend back to them. It was the most absurd thing. I had 5 sent back to me, and like Rachel was showing, I mean, they're like applications are huge. They're spending $8 to $10 to put that in the mail to send it back to me, for me to put NA in a box that I forgot to put it in. That doesn't matter because it's NA, so it's not applicable to my client, for me to just send it back to them. Oh, it made me so mad.
And like, even to just kind of explain even more how like ridiculous this was. So like some of the questions are like, oh, how many children do you have? And it's like child 1, 2, 3, 4. and you like can put in the information for all of them, like their names, where they live, blah, blah, blah. And okay, a logical person would be like, oh, well, I don't have any children, so I'll put N/A in all of the boxes for child 1. And because I don't have a child 1, why would I have childs 2, 3, and 4? Because that just doesn't make sense. But they still want the N/A, because what if you have a child number 2? You never know. So that's finally gone. We are all very excited. And then
Was that
February
policy?
Sorry?
The blank, was that a Trump policy?
It absolutely was.
Okay, so part of the process of making it harder.
Yeah. And then something else that they changed, February 22nd, 2021, Biden administration reverted back to the 2008 civics exam. So under the Trump administration, they tried to create a new civics exam, which made you answer more questions. I tried taking it, was actually a lot harder, especially if you think about the fact that a lot of these people did not grow up in the American school system. So they don't know a lot of the answers that you think might be easy for us. But so that thankfully they reverted back to the 2008 one, which is a lot easier. You have 10 questions, you just have to get 6 of them right. All right, and I'll let Alie take it away with deportation.
Yeah, so basically what Rachael was talking about was the affirmative part. So you are applying before you come into the United States, you're trying to get a visa before you come in, or some type of approval that says you're allowed to be here before you cross. Now, if you cross and you're in the United States without documents, then most of the time you get put into the removal or the deportation process, which is what this is. So in 1996, Congress enacted some revisions to the INA, which Rachael had mentioned earlier. Nothing has happened in immigration per Congress since 1996. I was born in 1995. So my entire lifetime, no changes, no comprehensive immigration reform, absolutely nothing has happened since these changes. And when these changes were made, immigration judges were put within the EOIR, which is under the executive branch. So think about that. We have 3 branches of government, separation of powers. We have a judicial branch. Immigration judges are not in the judicial branch. They are in the executive branch under the president, which means whenever the presidency changes, immigration policy changes per the executive branch policies. So they are purely executive officers. Every function of an immigration judge is within the discretion of the Attorney General, who is appointed by the president. Do you see where I'm going with this? So when an immigration judge is supposed to be the unbiased fact finder in removal proceedings, whether they are issuing that order and how they're issuing that order directly corresponds to executive presidential policies. You can go to the next slide. So this is kind of what I was just talking about. We have the separation of powers, but there is no Article 3, which means there is no judicial branch that has a check on this executive branch policy of immigration being under the president instead of under the judiciary. So there really isn't any oversight to have a checks and balance on this process, even though that was supposed to be the function of these 3 branches of government. Another issue with the way this is set up is judicial review. So if you think about cases, they go to the trial court, and then you can appeal to the Court of Appeals, and then you can appeal to the Supreme Court. So there's multiple levels of judicial review over the Article 3 judicial branch decisions. When you're talking about executive 1 branches, you're talking about administrative agencies. So these are all agency decisions. Because they're in the executive branch, they're not privy to the same judicial review that you would have in a judicial branch, Article 3 type judge-made decisions. So Congress really structured this in a way under the executive branch that there was no discretion to the fact finder. So an immigration judge is appointed, an immigration judge makes the decision under the executive branch. And if an immigrant falls within the statute, so Congress created these statutes that say these are the people, A, B, C, D, and E, who are deportable based on these instances, there is no discretion taken into that, regardless of the circumstances. So this is the example that I like to give. If someone's here undocumented, they've lived in this country basically their whole life, and they do have US citizen children. If they committed a minor offense, we get a lot of theft offenses, for example. Even if it was over 10 years ago, and she has US citizen children and she's been here for 15 years and she doesn't have any other citations except for this one theft and it was petty, then none of that is taken into account to determine whether they're deportable. It's just if you committed this crime and that crime is listed in the statute, you are now deportable, regardless of any other circumstances. I see someone has a question. What type of offenses? So there are a list of offenses in this statute. Not all of them are felonies, as well, to answer Richard's question. So most of them have to deal with a crime of moral turpitude. That's what the government calls it. So if it's a crime like theft, because that morally, if you are stealing something from someone else, that's a crime of moral turpitude. So we had someone, she was a older woman. We don't know why she kept stealing. She kept going to the mall, and her husband was a doctor, so she had no reason to steal. She had some mental health issues that were undiagnosed, and once we got her into counseling, she was fine. But she had 3 petty theft, like from Sears and Target and stores like that. That made her deportable. Husband, 2 kids. Besides that, I mean, she paid everything back. She went to a retail course. So she did everything that she should have done to remedy that. And any other US citizen who committed that crime, which we know happens all the time, wouldn't have this kind of hurdle to have to go over. And there's nothing to remedy that. So in criminal court, you have mitigating circumstances. So let's say you do commit a crime, but you have all of these circumstances. You came from a broken home, you went to a bad school district, you were abused, your parents never reported the abuse, there's some liability on them, you were removed from the home. Like, all of those things go into account in criminal court as a mitigating circumstance to determine what your sentence is. There are no mitigating circumstances in immigration. You meet it, that's it. They don't take into account anything else.
I just want to jump in and add to that. Like, this is the link between crim and immigration is so huge. Like, there's like a branch of immigration called crimmigration, where a lot of immigration and criminal lawyers like work, because if you do have an immigrant who is in criminal court, whatever their conviction could seriously injure their immigration status. So actually a lot, I think under New York, under federal, actually it might be required. Criminal lawyers have to actually meet with an immigration attorney to figure out what a plea might mean for someone's immigration status. And if they don't do that, actually it's an article or a 6th Amendment violation, because they didn't have access to proper.
Correct. It's also an ethical violation for the attorney. So you can get sanctioned as an attorney for giving bad legal advice, basically. And we've seen that a ton, where clients have come to us as an immigrant for an immigration case, but they had a different criminal attorney, and we've had to report attorneys who told them to take a plea But now that plea of guilty for that crime makes them ineligible for an immigration status. So it's really, really serious. And a lot of criminal attorneys don't understand the impact of pleading. And most people, it's a good plea. You want to accept the deal. For any other type of criminal defendant, you would accept the deal, except for an immigrant, because it messes up their entire immigration case.
Yeah. There's like New York State sends out charts too to immigration attorneys about, you know, how if they're if they're arrested or arraigned under a certain New York penal code, like what does that mean for their immigration status? Do we consider this a CIMT or a crime involving moral turpitude? Do we consider it an aggravated felony? Like they send out charts and it's like small font, like hundreds of pages where you just kind of go through and figure out what they were convicted of, what charge, what it means to, and just to figure it all out. It's a headache and it takes a while. And like I said, there's a whole branch of lawyers that do this because it's just that intense.
Okay. You can go to the next slide. So where I did a lot of research and a lot of work was the access to counsel part. So similarly or dissimilarly, talking about criminal court. So, you know, in criminal cases, you have a right to an attorney, and if you can't afford one, one will be appointed for you, and you have a right to counsel, access to counsel. Immigrants do not have that. So you have a right to counsel at your own expense. That is not paid for by the government. And so this really makes this not a clean fight. I mean, you have a government attorney prosecuting immigrants who are unrepresented, who don't speak the language, and in a complex area of law. So really the presence of attorneys on both sides would just even the playing field here, because you're going against a federally funded agency. You're going against ICE, and you have no access to counsel that is appointed to you from the government. You can go to the next slide. So if you are detained, you'll get picked up by ICE. They bring you to a detention facility and you're trying to fight your case. Again, attorney is not appointed for you. So luckily, if you get an attorney, they are going to come to the detention facility to try to get you out on bond. And then if you get out on bond, you'll be able to argue your case and actually meet with your attorney outside of detention. You have a much better chance of being successful. If you don't get out on bond, you're trying to fight your case with your attorney from inside detention, if you have an attorney, or you're just trying to figure out what to do next. Detention facilities are notorious for not allowing immigrants access to phones or visitation. So think about trying to fight your case. If you are lucky enough to have an attorney, which most immigrants don't have an attorney because they can't afford one, and you can't even get in contact with your attorney, or personal favorite, which is the most frustrating thing, and this has happened to me, is they get transferred and they don't tell you that they're being transferred. So I've called York Immigration Detention Facility and like, hey, can I talk to my client? And they're like, they're not here. Like, wait, what do you mean he's not there? Like, where is he? I don't know. He's not here. We don't track him. I mean, he was released from here. I don't know where he is. And then you spend like weeks trying to find your client because you have no idea where they are because they just got moved and no one told you that. Which makes it really difficult to be in contact with an attorney. It also makes it difficult for us to tell your family where you are because we don't know where you are and they're definitely not letting you get in contact with your family. So human rights organizations have looked into this, advocacy groups have looked into this. They try to do know your rights presentations. Obviously, the facilities don't like that happening in their facilities. So we try to do them in the community so people know what rights they do have and the type of access to counsel that they should be getting, even if, you know, they're getting the runaround from ICE on what that looks like.
Also, just to go off of that, I've like heard stories from attorneys that I know, because I'm not yet an attorney, but in immigration law, there's a form called a G28, which essentially you have to sign, get your client to sign saying, yes, this is my lawyer. And the one attorney was at the detention center and was like, oh, I'm trying to see my client. And they're like, well, you don't have a G28. They're not your client. And it's like, yeah, I know, because I haven't met them yet. I have the G28. I need them to sign it. Like, I'm going to represent them. They have to sign it. Like, how can I have them sign it without getting, like, I need to see them in order to have them sign it to let them know I'm their representative. It was just biggest headache. Anyway,
Yeah.
moving on.
So this is an old study. I'm trying to get a new one to, update the presentation. But nothing has really changed since this was done. The left chart, my left, I don't know how you're looking at it, but over here, the relief of the case termination. So as you can tell, if you've never been detained and you are represented by counsel, that's your best chance of success for your case. Best chance of success with a 60% success rate. If you were never detained and you're unrepresented, that drops drastically to 17%. If you were detained and then you were released, and you're represented by counsel, that's close to 40% and then drops significantly. And then the common area, which is what we see the most, is you're detained and you are unrepresented. You have a 2% success chance on your case. If you're lucky enough to have a representative, then you have a 21% success if you're detained and you're trying to fight your case there. So that's the pattern across the board of all of these studies, is if you're not detained and you have an attorney, that's your best chance of success. Yet we don't have a right to counsel for immigrants as a universal policy from the federal government, and we detain a lot of people. So you tend to be in that detained, unrepresented category. You can go to the next slide and I'm going to read this. Yes, it does vary by area. And I will also say, because I've been in Pennsylvania for the last 4 years, we are not much better, especially when one of our facilities is in the middle of nowhere, like rural Pennsylvania. And they really don't like letting people out or giving people access to an attorney in detention. So this chart, these correspond as far as the percentage of people who are represented by attorneys and their success rate. And then also the flip side of the graph is the percentage of people who are in detention. So if you look at the left, 78% of people in detention are from Mexico, but only 21% of people from Mexico are represented by an attorney. But 4% of people from China are in detention, and 92% of them are represented by counsel. So there's a direct correlation between what country you are from and being detained, and what country you are from and whether you have access to counsel. So if you go to the next slide, the good news for you guys in New York, not really any other state, but New York does have the Family Unity Project. It started in New York City, launched in 2013, super small. They were just doing a trial, but it is a public defender style program. So what I was saying, if you're in criminal court, you get appointed a public defender if you can't afford an attorney. That doesn't exist for immigration. But state by state, they can create certain programs. It's just not federally mandated. So New York City started it in 2017. New York State as a whole decided to start implementing this. So they're the first state to make legal representation available, with the caveat that it's only available to people who are detained and facing deportation. So if you were detained and then released, you no longer get this benefit. But if you are detained and you stay detained, because as I said, people who are detained are the most at risk, then rather than you trying to fight this on your own, you do get access to counsel for your immigration hearing. 2018, so 2017, this was proposed. There was no money for it. So it was a wonderful idea, but wasn't actually, implemented at all. 2018 New York State budget included $4 million to expand this program. They also got a match for another $10 million. Other caveat is you have to meet the federal poverty guidelines, which isn't very hard to meet. This was 2018, so it's not updated, but poverty, it's 150% is what we follow for immigration, at least. So a family of four, $37,000 is you would have to make under that in order to qualify for this program, which is not a lot of money for a family of four. So it's definitely possible to meet this. It's also hard to get these documents from people when, one, they're detained and they're trying to show that they meet the federal poverty guidelines, and two, they're undocumented. So they're not supposed to be working, but you know that they are working, and now you're supposed to provide some type of documentation to show they meet the federal poverty guidelines and also not get them in trouble for working illegally. So there's flaws, but it's a good idea. Like we're working towards it. There's still issues. So if you go to the next slide, in the grand scheme of things, people went up in arms about this when this was first announced in New York State. But I like to put it in perspective for everyone. So we need to look at the public protection criminal justice. So that's this yellow. So that's going up, as you can tell, the funding's going up from 2019 to 2023. But if you look at the pie chart here, public protection and criminal justice is still this little sliver right here. So although the funding's going up in the whole pie, it's still not that much of the budget. And then if you go to the next slide, they created this Indigent Legal Services Office, which is only 2% of the budget. So it's up 70%, and people were like, oh my God, you're putting millions of dollars into this budget. How could you spend our money like this? It's still a little tiny sliver compared to what the government spends on everything else. It looks like a huge jump, but it's really not. It's 2%. And if you look at corrections and community supervision, that's 52% of this budget. So, food for thought. You can go to the next slide. That's my whole spiel. So before we do review, does anyone have any questions on that? Because it's a lot to take in and to understand what's going on. Okay, Rachel, do you want to do the review?
Yeah, sure. So, we kind of started out with, it's not easy to immigrate to the United States illegally. It's very complicated. It costs a lot of money. It takes a lot of time. Immigration court is part of the executive branch, not the judicial. So there's really no great review process for it. Immigration judges do not have discretion to make their decisions. Richard in the chat posted, Buffalo has one of the worst approval ratings. We really do for our judges. Judge Baumgartner actually has a 99% denial rate in immigration court. And I think probably the one with the best chance still has like an 80% denial rate. So not great. We have 4 judges. Immigrants have a right to counsel only if it doesn't cost the government money. So they really don't have any access. And then if an immigrant is detained, they're less likely to win their case. New York is taking strides for the public defender program, like Alie pointed out. And as well as the chart showed you, access to counsel is incredibly important with helping these people win their cases. with that, apparently can't change the slide anymore to questions, but we'll open the floor to questions.
So actually, I have two questions, and I see Jill's got a question there. So I'll let Jill go first, and then we can go. And it's in the chat. You want me to read it?
I got it. That's okay.
Yeah, personal motivations. It's hard.
No, Alie, you go first.
It's really hard, and the burnout rate is super, super high. For me personally, immigration's really close to me. So my dad's first generation American. All my grandparents are immigrants, and my mom was born in Vietnam. So she has dual Vietnamese US citizenship, and she was born during the Vietnam War. My grandpa was in the Vietnam War, met my grandma there. My mom was born there. And then when she was about 18 months old, he was able to bring her and my grandma to the US. And she was mixed, and people didn't like the Vietnam War. People didn't think we should have been over there. It was highly contested. And so there was a lot of discrimination against people who are Vietnamese and from Vietnamese mixed race. And so I grew up with that kind of in the background of my family. And I grew up, my Nana was my babysitter basically when I was little, and people thinking she was my nanny or some other person because I present white and she doesn't. So that what is like a personal motivator for me is that I'm really close to it. So I know we all talk about, well, this is a country of immigrants and everyone's an immigrant, but for a lot of people, it's like their great grandfather's dad or something. But for me, it's my parents. So it was really close for me. So that was something I always felt personally close to, and that's kind of what keeps me going, is this family piece of it. But it is really hard, and you hear terrible things and terrible stories that people tell you, and you hear it, and it's traumatic, and you know people are suffering from trauma, and then you still have to give them bad news. Like, you still have to be like, hey, I know, and this was a U visa case, I know that your mom's boyfriend, who's 32 years old, raped you and you're 14, but your U visa isn't going to be approved for 4.5 years. Like, that's terrible. It's terrible to have to tell someone. So you have to find that. I think this is the one piece of law where if you are not passionate about it and your heart's really not in it, you can't do it, and you shouldn't do it, because it's actually more damaging to your clients if you're not committed to it.
So I would say for me, like, my personal motivation, I mean, my family also immigrated here, but not as closely related to me. It was like my great grandparents. So my personal motivation is more so just like, I want to help people. Like, I remember seeing like the videos and photos of kids in cages under the Trump administration and just being very annoyed and being like, that's not right. Like, this is supposed to be, I kind of want to help people, like I said, but make this the country that we claim to be, you know, like, we claim to be a country of immigrants and we were a melting pot, and I just think we can do better. And that's kind of my personal motivation, is almost spite, where I'm like, we should do better and we can do better and we have done better. And then to go for the second part, like, what do you do in order to deal with frustration? I just kind of look back at the cases that I've had that are successful, and, you know, they're kind of few and far between, but when you do get, you know, a green card approved, or you see someone get their citizenship, it really is all worth, part of my language, is just like all the bullshit that you go through with USCIS. It's definitely rewarding to see that. And it just kind of makes it all that much better. Alie, there are a few more questions. The next one is definitely more so up your alley in the chat.
Yeah, to locate. So I mean, this took like 2 days and it was such a waste of time. It was so unnecessary. So we had to call, so we called detention. They said that he wasn't there, but he had an ankle bracelet. So then we called the person who was supposed to be monitoring the ankle bracelet. Ankle bracelet person said, no, he has someone that he reports to that's not ICE, but is like this other company. It was basically like a third party contractor. And then like what Rachel said, then they wouldn't release information to us because we needed to show proof that we were actually the attorney. So then we had to go back and make copies and get all these documents that showed we were actually his attorney, that we were actually going to meet him on these occasions. Finally found him. Well, so they finally gave us his phone number. Now, another thing with immigrants, their phone numbers change all the time. Like they're constantly changing,
Or they don't have their voicemail set up.
Correct. Don't have their voicemail set up, or they don't pay their bill and then it gets bounced to the next month. You can't get in contact with them. So then we had his phone number, tried calling for like 2 weeks, couldn't get a hold of him. Finally, his phone comes back on and he called us. So really, you just have to be a detective, like your own detective, and because no one else is helping you, like no one else knows. I'm like, you're the US government. He was in your custody. How do you not know where he is? As far as feeling guilt, I mean, another part of this law is you just have to be able to tell yourself that you did the best that you could do, and it's an imperfect system, and you can't take that, like you can't put that on yourself, because if you put that on yourself, that's when you start to burn out super quick. So I mean, it was frustrating, but I knew that I did what I did everything I could have done to try to find him, and that was on the government, that wasn't on me. And thankfully we were able to find him, and we got his appeal submitted and it's processing right now, and I think everything's going to be okay. But yeah, I mean, it's a bad phone call, you know, I called his wife and was like, hey, I don't know where he is. If he comes home, can you let me know? Like, you're probably going to see him before I am if he actually did get released on an ankle bracelet. So yeah, it's an imperfect system. And to Richard's comment, yes, third party, for profit. So the government pays this ankle bracelet company to monitor the immigrants so that the government doesn't have to monitor the immigrants.
All right, and then we had one more question in the chat. So the reason for the 20-30 year wait list, part of it for the processing forms part is just, yeah, like lack of employees and funding and just the sheer amount of them. But also with like the visa bulletin. So the United States caps the amount of green cards that we give out every year. I think I'm trying to pull up like the number right now. For family-based, we limit it to 226,000 green cards a year, which those numbers also haven't been being met lately. Last summer, there was actually a committee in front of Congress with the USCIS having to explain why they haven't been issuing the amount of green cards that are allotted in light of especially all the backlogs. But yeah, so it's kind of everything. It's the cap on the amount that are allowed to be given out. It's the lack of employees, lack of funding, deliberately slowing them down. The Trump administration definitely changed a lot of things around where certain things need to be filed in to one service center for them to just transfer it to another service center like a week or two later, to then have it be in that one for a while and then go to a whole other department, and it's just unnecessarily making it change hands. So a lot of reasons. What structural changes do you want to be in place? And given that it's been difficult for people to get vaccines, how is that impacting migration? Structural changes, I would say not getting rid of a lot of that back and forth would be great, with where applications are getting sent and having it, again, like I said, get diverted to other like field offices. It's definitely like a hassle that needs to go away. They changed the no blame policy, which was great. Alie, can you think of anything you'd want?
I mean, I would move immigration judges to the judicial branch because that makes
too.
sense to me. I think judges should be in the judicial branch, not the executive branch. That would be the perfect world. I just don't see that happening. You would really have to gut this entire thing. And if Congress hasn't even been able to pass any type of immigration law since 1996, I don't really put my faith in them to be able to completely move a whole administrative agency into another branch of government. But that would be my wish if I had a wish of something that should change. As far as vaccines, at least from the work I was doing, I was dealing with people who are crossing illegally and who are undocumented. So they're not getting stopped because they're not going through immigration. So no one's checking their vaccination status. But yes, people who are trying to go through the legal way and are trying to apply before they enter are going to have to start showing proof of vaccination. And if you live in a country where there are no vaccines, you're going to not be able to come in to the US, even if your application gets approved.
Another one, are there many adoptions? If so, how does that work? So I don't deal with adoptions that often. Those are some things like a lot of the adoption agencies kind of work with. But those ones, they don't have to wait that period. They're going to be considered a qualifying relative or an immediate relative of a US citizen, most likely. So there would automatically be a visa available for them. So they don't have to do that long wait time. If someone gets adopted and loses all their paperwork, I would imagine there's a way to remedy that. I think it depends on what kind of paperwork that they lost. Alie, do you have anything to add?
Yeah, I don't do a ton of adoption stuff either, but I did do the unaccompanied minors and unaccompanied children, trying to get them SIJ, which is special immigrant juvenile visas. And with that, the issue is you have to, it's a combination of immigration law and family law. So you have to get custody transferred over to someone in the United States, which means the parent in the home country has to give up all rights. And that's really hard to get service to them in their home country and to get them to give up their rights in order to give someone full custody of that child in the United States. And then you have to go through family court first. So you have to actually get the family court order. And then once you get all of the custody stuff done in family court, you transfer all of that over into immigration, and then you go in front of an immigration judge to get the visa. So that's the closest context I have in terms of adoptions. But with adoptions, it's the same thing. You have to have the parental rights terminated. And at least from the clients we have, mostly are from Mexico and Guatemala, El Salvador, and Honduras. Those parents are sending them away to give them a better life. Like, there is no reason for termination. There's no neglect. There's no abuse. There's no reason to terminate their rights. In their mind, they're trying to help to give them a better life by sending them here. So it's hard to, it's hard to get to explain to them that terminating their rights would actually give someone custody here, which would actually help their child get status in the US. No parent who isn't actually abusing their child wants to give up their rights.
Alie and Rachel, we're just about at the end of time, and I want to just make one thing clear and then ask you a question, and that is that it's important to remember, right, that the entire system is funded through the fees, which is why it's so expensive, right? I mean, people I'll often wonder, like, oh, like, for example, in my case, my husband's paperwork, oh, you got married, that's automatic. It's not automatic, and it costs thousands and thousands of dollars just to file paperwork for someone to read that they probably don't read. Or if they read, they send it back to you because you left it blank, right? So it's a system that is not funded through the government's US budget. It is funded through the fees it collects, and those fees keep going up and up and up, and they hire fewer and fewer and fewer people as a deterrent, right? So I think that's important to bear in mind. I just wondered, Rachel and Alie, if we can conclude with what your Canisius education meant to your dedication to this work, and if Spanish contributed to that.
So I would say Canisius definitely contributed, Spanish as well, through your 217 class with the whole immigration unit. Like that kind of first opened my eyes to immigration. But also Professor Fajardo Hayward, absolutely adore her. She taught a human rights class, and that coupled with your immigration unit kind of led me to want to become an immigration attorney. So I think, and doing some like Canisius service days with like Vive, like all kind of culminated in me becoming an immigration attorney at a nonprofit. So, or a future immigration attorney at a nonprofit.
Yeah, I mean, maybe you watched my video. Apparently, I'm the poster child of Jesuit education at Canisius now. So you can watch that and get to know my thoughts on it. But I think for me, it was all about taking the action. And I talk about this when I was interviewed. It's really like, okay, you have this problem, but instead of complaining about it, and instead of doing the Band-Aid fix of like, okay, this is going to get us through until tomorrow. The Jesuit education and Canisius, and being involved with Richard, I went to the Keno Border Initiative with him through campus ministry, and I also took Professor Fajardo Hayward's courses and being in international relations and just meeting people. I worked with the refugee community in Buffalo, so I volunteered at Energy, which is an after-school program run through Weedy. If you heard of the West Side Bazaar or the Westminster Education Initiative, it's through that, and they have an after-school program for refugee children. They also have one called Fly. Journey's End has stuff, Jericho Road has stuff, Vive has stuff, the International Institute of Buffalo has stuff, and I just kept meeting people. And the more people you meet and the more you get out in the community, the more you learn about these organic issues. And so I knew about all these issues, and there are nonprofits that have to do these Band-Aid fixes. Like when someone's hungry, you have to give them food. But I then started taking the approach, and what these courses and professors in Canisius helped me think about is like, well, why? Like, why are people hungry? Why are people homeless? Why don't people have access to immigration attorneys? And like, let's not do the Band-Aid fix, but let's actually figure out the structural issue. And like, instead of giving them a sandwich because they're hungry, why don't we try to get them a job or go back to school? Or like, let's fix the structural problems and the long-term solutions of how we're going to create sustainable systems that are functioning for the benefit of everyone. And I think my whole thought process changed when I was able to get that from Canisius. And I spoke Spanish in Pittsburgh, which isn't really a city you would think you would speak a lot of Spanish. I spoke Spanish every day I was at work, every day. And I'm not as fluent as I would like to be. I wasn't using it for 3 years of law school, except for when I was at work, but it was hugely instrumental. And my clients, even if they couldn't fully understand the complex stuff, were always so appreciative. Every time they were like, thank you so much for trying, like, and for accommodating me and not expecting me to come into this office and just read all of this stuff in English. Like, they just appreciated it so much that I wanted to speak their language. So it's so helpful, especially now with the climate we're in, and Spanish is on the rise. So keep up with it. Don't let it fall to the wayside.
Yeah, unfortunately, my Spanish is not as utilized. We have a lot of Arabic speakers, or like Dari and Farsi, but I do get the occasional like 1 or 2 Spanish speaking clients, and it makes me very excited that I can try and say something, even if it is just in like very basic Spanish, it's always appreciated by them.
Well, thank you, Rachel and Alie, for this enlightening and informative discussion. And thanks to the students for your questions and your attention. I hope you found this useful and informative. And it will prepare us for next week. And I would just remind you that next week we have on the 28th, Tuesday, the immigration simulation, which you will be dealing with the legal repercussions of this in a role-playing game. And Rachel and Alie, if you are interested, we have a version of that now in Spanish that we do virtually. So if you are interested in joining and participating, we would welcome your participation, perhaps even as visa interviewers, should you be so inclined. And then on Thursday, we start our first dual immersion session with ITESO Guadalajara. So also investigate that institution. Their information is in D2L. All right, so thank you all, Alie and Rachel. Lovely to see you, even if virtually, and we will be in touch.
Thanks, Richard.
And the rest of you can say thank you too.
Thank
you.
And Richard, if you want to share my contact information, feel free. If anyone wants my cell or email or anything, just let them know.
Okay, great.
Yeah.
Wonderful.
Bye.
Thank you both.
Thank you.
All right, bye.
All right.
I have something I want to ask you. Well, I wanted to share this. It's kind of
Let me stop the
basic.
recording.
Okay.